HR marked my retaliation complaint as thoroughly reviewed and unsubstantiated. The evidence file had never been opened. My name is Iris. I worked as a regional compliance officer for a financial services company in Phoenix. We had 11 branch locations across Arizona and New Mexico. I had been with the company for 7 years. 4 months ago, I reported a compliance violation to my supervisor. The violation was documented. The evidence was clear. One of our branch managers had been approving loans that didn't meet our underwriting standards. The manager's name was Todd Brennan. He ran our Scottsdale branch. He had been with the company for 12 years. 2 weeks after I filed the compliance report, I was placed on a performance improvement plan. The PIP cited 3 issues: failure to meet departmental communication standards, insufficient collaboration with branch leadership, and delayed response times on routine inquiries. None of these issues had been mentioned in my previous performance reviews. I had received exceeds expectations ratings for the past 4 years. I filed a formal retaliation complaint with HR on June 18th. I submitted 47 pages of documentation, email chains showing my communication was timely and professional, performance reviews showing consistent high ratings, the original compliance report showing the violation I had identified, calendar records showing I had not delayed any responses. HR's employee relations director was a woman named Diane Foster. She had been with the company for 9 years. I received her response 8 days later. Subject line: retaliation complaint. Case closed. Body: Iris. After thorough review of your complaint and all available evidence, we have determined that the performance improvement plan was issued based on legitimate business concerns and does not constitute retaliation. Your compliance report was handled appropriately through proper channels. This matter is now closed. Please focus on meeting the requirements outlined in your PIP. Diane Foster, Director of Employee Relations. I read the email 3 times. Then I checked the document tracking system we used for HR submissions. The evidence file I had submitted showed 0 views, 0 downloads, 0 access logs. Diane had closed the complaint without opening the evidence. I took a screenshot of the access log. Then I did something I had never done before. I saved every document to a personal drive, and I called an employment attorney. The attorney's name is Richard Caldwell. His office was in downtown Phoenix, a 15-minute drive from my apartment. I found him through a referral site for employment law specialists. His profile listed 23 years of experience in workplace retaliation cases. I called his office at 2:30 p.m. on a Thursday. The receptionist answered. "Caldwell Employment Law, how may I help you?" "I'd like to schedule a consultation. I believe I'm experiencing workplace retaliation." "Let me check Mr. Caldwell's availability. Can you give me a brief overview of the situation?" I reported a compliance violation. I was placed on a performance improvement plan 2 weeks later. I filed a retaliation complaint with HR. They closed it without reviewing my evidence. "How do you know they didn't review it?" "The document management system tracks file access. My evidence file shows 0 views." "I see. Can you come in tomorrow at 11 a.m.? "Yes. I'll need you to bring all documentation: emails, performance reviews, the compliance report, the HR complaint, anything related to the timeline. I have everything." "Good. See you tomorrow." I hung up. I spent the rest of the afternoon organizing my files. I created a master timeline document. Every date, every email, every interaction with Todd, with my supervisor, with HR. I printed everything. I also saved digital copies to 3 separate locations: my personal laptop, an external hard drive, a cloud storage account. I did not tell anyone at work that I had consulted an attorney. I did not mention it to my supervisor. I did not respond to Diane's email closing the complaint. I simply continued working. The next morning, I arrived at Richard Caldwell's office at 10:50 a.m. The building was professional, modern, glass and steel. I took the elevator to the 4th floor. The receptionist greeted me. "Iris?" "Yes." "Mr. Caldwell is ready for you. Conference room 2, down the hall on the left." I walked to the conference room. Richard was already there, sitting at a large table. He was in his 50s, gray hair, glasses, calm expression. He stood and shook my hand. "Iris, thank you for coming. Please, have a seat." I sat down. I placed my folder of documents on the table. "Tell me what happened," he said. I walked him through the timeline. The compliance violation I reported on May 3rd, Todd Brennan approving loans outside underwriting standards, the documentation I had submitted, the performance improvement plan issued on May 17th, 2 weeks later, the retaliation complaint I filed on June 18th with 47 pages of evidence, Diane Foster's response on June 26th, closing the complaint as unsubstantiated, the access log showing 0 views of my evidence file. Richard listened without interrupting. He took notes on a legal pad. When I finished, he leaned back in his chair. "Do you still have access to that document management system?" "Yes." "Can you take another screenshot today showing the file still hasn't been accessed?" "Yes." "Do that. Send it to me by end of day." "Okay." He picked up one of my printed emails. "This is the compliance report you filed. Who did you submit it to?" "My direct supervisor, Karen Walsh, and the corporate compliance department." "What happened with the report?" "I don't know. I never received a follow-up. Karen told me it was being handled appropriately." "Did the compliance department ever contact you?" "No." Richard made a note. "And this performance improvement plan, you said none of these issues had been raised before?" "Correct. My last performance review was in March. I received exceeds expectations in all categories." "Who issued the PIP?" "Karen Walsh, my supervisor." "Does Karen report to anyone?" "Yes, the regional VP, Michael Torres." "Did you ever speak with Michael about this?" "No. The PIP process is handled at the supervisor level." Richard flipped through more documents. "How long is the PIP?" 90 days. It started May 17th. It ends August 15th. "What happens if you don't meet the requirements?" "Termination." He nodded slowly. "And you filed your retaliation complaint on June 18th, during the PIP period?" "Yes." "That's actually good timing. It establishes a clear pattern. You report a violation, you're put on a PIP, you complain about retaliation, the complaint is dismissed. If they terminate you at the end of the PIP, that's 3 acts of retaliation in sequence." I said nothing. "Let me ask you directly," Richard said. "Do you think they're going to terminate you?" I thought about it. "I don't know. The PIP requirements are vague. Improve communication, increase collaboration. There's no objective metric. They can say I failed regardless of what I do. That's common in retaliatory PIPs. Subjective standards, no clear path to success." "What can I do?" Richard put down his pen. "You have a strong case for retaliation. The timeline is clear, the evidence is documented, and the fact that HR closed your complaint without reviewing the evidence is particularly damaging. So what's the next step? We file a complaint with the Arizona Civil Rights Division. It's the state agency that handles employment discrimination and retaliation claims. They'll investigate. If they find merit, they'll issue a right to sue letter. Then we can file in federal court. How long does that take? The state investigation usually takes 3 to 6 months, sometimes longer. And if they terminate me during that time? That strengthens your case. It shows they continued the retaliatory pattern even after you filed an external complaint. I absorbed that. What do I need to do? I'll draft the complaint. You'll need to review it and sign it. I'll file it on your behalf. Then we wait for the state to investigate. What should I do at work in the meantime? Document everything. Every interaction with your supervisor. Every PIP check-in. Every email. Keep doing your job to the best of your ability. Don't give them any legitimate reason to terminate you. And if they do terminate me, then we add wrongful termination to the complaint. I nodded. One more thing, Richard said. My fee structure. I work on contingency for cases like this. I take 35% of any settlement or judgment. If we don't win, you don't pay. But there are some costs, filing fees, expert witnesses if needed, that you'd cover up front, usually a few $100s total. That's fine. Good. I'll have the complaint drafted by next week. I'll send it to you for review. Once you approve it, we file. We shook hands. I left his office. I drove back to my apartment. I took another screenshot of the access log for my HR evidence file. Still 0 views. I sent it to Richard. Then I opened my laptop and continued working. The following week passed slowly. I attended my scheduled PIP check-in with Karen on Wednesday. She sat across from me in a conference room. She had a notepad in front of her. How are things going, Iris? Fine. I wanted to check in on your progress with the communication improvements we discussed. I've been sending weekly updates to all branch managers. I've been responding to emails within 2 hours. I've scheduled monthly collaboration calls with each region. That's good. Have you noticed any improvement in your relationships with the branch leadership? I've received positive feedback from several managers. Which ones? I named 3 managers who had replied to my emails with appreciation. Karen made a note. And what about Todd Brennan? I looked at her. What about him? Have you worked on improving your communication with him specifically? Todd and I communicate as needed for compliance matters. He's mentioned that he finds your tone in emails to be confrontational. Can you give me an example? He didn't provide specifics, just general feedback. I said nothing. I'd like you to focus on that, Karen said. Building a more collaborative relationship with Todd. He's a senior branch manager. His feedback matters. Understood. The meeting ended. I walked back to my desk. I opened my email. I composed a message to Richard. Subject line: PIP update. Body: Karen asked me to focus on improving my relationship with Todd Brennan, the manager I reported for the compliance violation. She said he finds my emails confrontational, but couldn't provide examples. This feels like they're building a case for failure, regardless of my actual performance. Richard replied an hour later. Document this. Take notes immediately after every PIP meeting. Include exact quotes if possible. This is exactly the kind of subjective, moving target behavior we need to show. I saved his email. Then I created a new document titled PIP Meeting Notes, Confidential. I recorded everything Karen had said. The date, the time, her questions, her feedback about Todd. I saved it to my personal drive. 3 days later, Richard sent me the draft complaint. It arrived at 9:15 a.m. I opened the attachment. The letter was 12 pages long. Charge of discrimination. Arizona Civil Rights Division. Charging party. Iris Mendez. Respondent. Pinnacle Financial Services Group. The complaint outlined the facts in precise legal language. On May 3, 2024, Charging Party filed an internal compliance report identifying loan approval violations by branch manager Todd Brennan. On May 17, 2024, 14 days after filing the compliance report, Charging Party was placed on a performance improvement plan, citing vague and previously unraised performance concerns. On June 18, 2024, Charging Party filed an internal retaliation complaint with Human Resources, submitting 47 pages of supporting documentation. On June 26, 2024, HR Director Diane Foster closed the complaint as unsubstantiated after thorough review. Document access logs show that the evidence file submitted by Charging Party was never opened or reviewed by HR personnel. The complaint continued for several more pages, citing specific violations of Arizona employment law and federal anti-retaliation statutes. The final section listed the requested relief: reinstatement to position without PIP, back pay for any lost wages, compensatory damages for emotional distress, punitive damages for willful retaliation, attorney's fees and costs. I read the entire document twice. Then I signed it electronically and sent it back to Richard. He filed it with the Arizona Civil Rights Division on July 9th. I received a confirmation email from the state agency on July 11th. Charge received. Case number 2024 AZ0847. Your complaint has been received and assigned to investigator Sarah Chen. You will be contacted within 30 days regarding next steps. I saved the confirmation email. Then I went back to work. The PIP period continued. I attended another check-in with Karen on July 24th. "How are things progressing?" she asked. I've continued sending updates. I've maintained response times under 2 hours. I've scheduled collaboration meetings with all branch managers. Have you had any direct conversations with Todd? The following week passed slowly. I attended my scheduled PIP check-in with Karen on Wednesday. She sat across from me in a conference room. She had a notepad in front of her. "How are things going, Iris?" "Fine." "I wanted to check in on your progress with the communication improvements we discussed." "I've been sending weekly updates to all branch managers. I've been responding to emails within 2 hours. I've scheduled monthly collaboration calls with each region." "That's good. Have you noticed any improvement in your relationships with the branch leadership?" "I've received positive feedback from several managers." "Which ones?" I named 3 managers who had replied to my emails with appreciation. Karen made a note. "And what about Todd Brennan?" I looked at her. "What about him?" "Have you worked on improving your communication with him specifically?" "Todd and I communicate as needed for compliance matters." "He's mentioned that he finds your tone in emails to be confrontational." "Can you give me an example?" "He didn't provide specifics, just general feedback." I said nothing. "I'd like you to focus on that," Karen said. "Building a more collaborative relationship with Todd. He's a senior branch manager. His feedback matters." Understood. The meeting ended. I walked back to my desk. I opened my email. I composed a message to Richard. Subject line: PIP update. Body: Karen asked me to focus on improving my relationship with Todd Brennan, the manager I reported for the compliance violation. She said he finds my emails confrontational, but couldn't provide examples. This feels like they're building a case for failure, regardless of my actual performance. Richard replied an hour later. Document this. Take notes immediately after every PIP meeting. Include exact quotes if possible. This is exactly the kind of subjective, moving target behavior we need to show. I saved his email. Then I created a new document titled PIP Meeting Notes, Confidential. I recorded everything Karen had said. The date, the time, her questions, her feedback about Todd. I saved it to my personal drive. 3 days later, Richard sent me the draft complaint. It arrived at 9:15 a.m. I opened the attachment. The letter was 12 pages long. Charge of discrimination. Arizona Civil Rights Division. Charging party. Iris Mendez. Respondent. Pinnacle Financial Services Group. The complaint outlined the facts in precise legal language. On May 3, 2024, Charging Party filed an internal compliance report identifying loan approval violations by branch manager Todd Brennan. On May 17, 2024, 14 days after filing the compliance report, Charging Party was placed on a performance improvement plan, citing vague and previously unraised performance concerns. On June 18, 2024, Charging Party filed an internal retaliation complaint with Human Resources, submitting 47 pages of supporting documentation. On June 26, 2024, HR Director Diane Foster closed the complaint as unsubstantiated after thorough review. Document access logs show that the evidence file submitted by Charging Party was never opened or reviewed by HR personnel. The complaint continued for several more pages, citing specific violations of Arizona employment law and federal anti-retaliation statutes. The final section listed the requested relief: reinstatement to position without PIP, back pay for any lost wages, compensatory damages for emotional distress, punitive damages for willful retaliation, attorney's fees and costs. I read the entire document twice. Then I signed it electronically and sent it back to Richard. He filed it with the Arizona Civil Rights Division on July 9th. I received a confirmation email from the state agency on July 11th. Charge received. Case number 2024 AZ0847. Your complaint has been received and assigned to investigator Sarah Chen. You will be contacted within 30 days regarding next steps. I saved the confirmation email. Then I went back to work. The PIP period continued. I attended another check-in with Karen on July 24th. How are things progressing? She asked. I've continued sending updates. I've maintained response times under 2 hours. I've scheduled collaboration meetings with all branch managers. Have you had any direct conversations with Todd? 2 weeks later, I received an email from Sarah Chen, the investigator at the Arizona Civil Rights Division. Subject line: Case 2024 AZ0847. Initial review complete. Body: Ms. Mendez, I have completed my initial review of your complaint. I will need to conduct interviews with relevant parties at Pinnacle Financial Services. I have sent a formal inquiry to the company's legal department requesting documentation and witness availability. I will keep you updated on the progress. Please continue to document any additional retaliatory actions. Sarah Chen, Investigator, Arizona Civil Rights Division. I forwarded the email to Richard. He replied, "Good. The company now knows there's an active state investigation. That changes the dynamic. They'll have to be careful about how they proceed with your PIP." But the PIP continued on schedule. On August 14th, 1 day before the PIP was set to end, I received a meeting invitation from Karen. Subject line: PIP Final Review, August 15th, 9 a.m. Attendees: Karen Walsh, Michael Torres, Regional VP, Diane Foster, HR Director. I stared at the invitation. Michael and Diane had never attended a PIP meeting before. Their presence meant one thing. They were going to terminate me. I forwarded the invitation to Richard. He called me 20 minutes later. "They're going to fire you tomorrow," he said. "I know." "Are you prepared for that?" "Yes." "Okay. Here's what you need to do. Go to the meeting. Let them speak first. Don't argue. Don't defend yourself. Just listen. If they terminate you, ask for the decision in writing. Don't sign anything. Tell them you need time to review any documents. Then leave." "Okay. Call me immediately after the meeting. We'll discuss next steps." "Understood." I hung up. I spent the rest of the day organizing my desk. I removed all personal items. I saved final copies of my work files to my personal drive. I went home early. That night, I barely slept. The next morning, I arrived at the office at 8:30. The meeting was at 9. I sat at my desk and waited. At 8:55, I walked to the conference room. Karen, Michael, and Diane were already there. I sat down. Michael spoke first. "Iris, thank you for joining us. We're here to discuss the conclusion of your performance improvement plan." I nodded. "Karen and I have reviewed your progress over the past 90 days. We've also gathered feedback from branch leadership." He paused. "Unfortunately, we haven't seen the level of improvement we need to see. The feedback from branch managers, particularly regarding collaboration and communication, remains inconsistent." "Which branch managers provided negative feedback?" I asked. Michael glanced at Karen. "That's not something we disclose," he said. "But the overall pattern is clear. You haven't met the standards outlined in the PIP." "The PIP didn't outline specific standards. It used subjective language. I asked for clarification multiple times and didn't receive it." Diane spoke. "The PIP process is designed to be flexible and responsive to evolving business needs. The expectation was clear: improvement in communication and collaboration. I documented every action I took to meet those expectations. I can provide that documentation if—" "We've made our decision," Michael said. "Effective today, we're terminating your employment." The room was silent. "This is retaliation," I said. "I reported a compliance violation. You put me on a PIP 2 weeks later. I filed a complaint with HR that was never properly reviewed. And now you're terminating me while there's an active state investigation." Michael's expression didn't change. "This decision is based solely on performance. It has nothing to do with any complaints you've filed." "I'd like this in writing," I said. Diane slid a document across the table. "This is your termination letter. It outlines the reasons and your final paycheck information." I picked up the letter. I read it quickly. The language was vague. Failure to meet performance expectations. Insufficient improvement during PIP period. No specific examples. "I'm not signing anything today," I said. "I need time to review this." "You don't need to sign the termination letter," Diane said. "It's effective regardless." "Fine." I stood up. "When is my last day?" "Today," Michael said. "We'll need you to return your laptop and access badge before you leave." I nodded. I walked out of the conference room. I went to my desk. I packed the few remaining personal items. I wiped my work laptop. I gathered my badge and access card. I walked to HR and handed everything to the receptionist. Then I left the building. sat in my car in the parking lot. I called Richard. They terminated me, I said. What reason did they give? Failure to meet PIP standards, insufficient improvement, nothing specific. Did they give you anything in writing? A termination letter. I didn't sign anything. Good. Send me a copy of that letter today. I will. Okay, here's what happens next. I'll amend your state complaint to include wrongful termination. The state investigation will continue. This actually strengthens your case significantly. They just terminated you while under active investigation for retaliation. How long will the investigation take? 3 to 6 months, sometimes longer. But we have a strong case now. Documented retaliation, unreviewed evidence, termination during investigation. Most companies settle before trial when the facts are this clear. And if they don't settle? Then we go to court, and we win. I hung up. I drove home. I sat in my apartment and processed what had happened. I had been with Pinnacle Financial for 7 years. I had excellent performance reviews. I had reported a legitimate compliance violation, and I had been terminated for it. But I had also done something they hadn't expected. I had documented everything, and I had filed before they could finish the retaliation. The next week, Richard filed an amended complaint with the Arizona Civil Rights Division. The amendment added wrongful termination to the original retaliation claims. I received confirmation from investigator Sarah Chen that the amendment had been accepted. Then I waited. The first month passed slowly. I filed for unemployment. Pinnacle contested it, claiming I was terminated for performance reasons. I submitted my documentation to the unemployment office. The performance reviews showing excellent ratings. The timeline showing the PIP started 2 weeks after I reported the compliance violation. The unemployment claim was approved. Pinnacle's contest was denied. I started applying for new jobs. It was difficult. Explaining a termination, explaining a gap, explaining why I left my previous role. I didn't mention the retaliation case in interviews. Richard had advised me not to. But the job search was slow. In September, 2 months after my termination, I received an update from Sarah Chen. Subject line: Case Investigation Update. Body: Miss Mendez. I have completed interviews with several witnesses at Pinnacle Financial. I have also reviewed the documentation you submitted, including the access logs showing your evidence file was not reviewed by HR. I am currently preparing my findings report. I expect to have a determination within 60 days. Sarah Chen. 60 days. That would be November. I forwarded the email to Richard. He replied, "This is good progress. The investigator is being thorough. That usually means she's found merit in your complaint." I continued applying for jobs. In October, I received an interview for a compliance position at a different financial services company. Smaller firm, local operations only. The interview went well. They asked about my departure from Pinnacle. I said, "I reported a compliance violation and was subsequently terminated. I'm currently involved in a legal proceeding related to that termination, which I'm not at liberty to discuss in detail." The interviewer nodded. "I appreciate your honesty. We'll be in touch." I didn't get the job. The feedback was vague. We decided to go with a candidate whose experience aligned more closely with our immediate needs. I suspected they had called Pinnacle for a reference. I suspected Pinnacle had not given a positive one. In early November, I received another email from Sarah Chen. Subject line: Determination Letter. Case 2024 AZ0847. I opened it immediately. The email was brief. Body: Miss Mendez, please see the attached determination letter regarding your complaint. I have found reasonable cause to believe that Pinnacle Financial Services engaged in unlawful retaliation. You now have the right to file a civil lawsuit in federal or state court. Please contact your attorney regarding next steps. Sarah Chen. I read it 3 times. Then I opened the attachment. The determination letter was 6 pages long. Arizona Civil Rights Division, Determination of Reasonable Cause. Case number 2024 AZ0847. Charging party, Iris Mendez. Respondent, Pinnacle Financial Services Group. Findings. After thorough investigation, including witness interviews and document review, I find reasonable cause to believe that respondent engaged in unlawful retaliation against charging party. Evidence supporting determination. Charging party filed a legitimate compliance report on May 3, 2024. Charging party was placed on a performance improvement plan on May 17, 2024, 14 days after filing the report. The PIP cited performance issues that had never been raised in prior reviews and used vague, subjective standards. Charging party filed an internal retaliation complaint with HR on June 18, 2024, submitting 47 pages of supporting evidence. HR Director Diane Foster closed the complaint on June 26, 2024, claiming thorough review, despite document access logs showing the evidence file was never opened. Charging party was terminated on August 15, 2024, one day after completing the PIP period, despite documentation showing efforts to meet stated requirements. The termination occurred while an active investigation was pending with this agency. Conclusion. The temporal proximity between the protected activity and the adverse actions, combined with the lack of legitimate justification for those actions, establishes a pattern of retaliation. The failure of HR to review submitted evidence before dismissing the internal complaint demonstrates procedural irregularity and suggests pretext. Right to sue. Charging party is hereby issued a right to sue letter and may file a civil action in court within 90 days of receipt of this determination. I forwarded the letter to Richard immediately. He called me 10 minutes later. "We have them," he said simply. "What happens now?" "I file a lawsuit in federal court. We sue for retaliation, wrongful termination, and intentional infliction of emotional distress. We ask for reinstatement, back pay, front pay, compensatory damages, and punitive damages." "How long will that take?" "Litigation can take a year or more, but most employment cases settle within 6 months, especially when the state has already found reasonable cause." "You think they'll settle?" "I think they'll have to. The evidence is too strong. The state's determination is damning, and if we go to trial, a jury will see that HR closed your complaint without even reading your evidence. That's indefensible." "Okay. I'll draft the complaint this week. We'll file by the end of the month." "Thank you, Richard." "You did the hard part, Iris. You documented everything. You stayed calm. You didn't give them any ammunition. Now we finish it." We hung up. I sat at my kitchen table. It was a Wednesday afternoon in November, 4 months since I'd been terminated. I thought about the day I reported Todd's compliance violation. I thought about the PIP meeting where Karen told me to improve my relationship with the person I'd reported. I thought about Diane's email closing my complaint after her thorough review. I thought about the access log showing 0 views. They had been so certain they could dismiss me. They had been so certain I would just accept it. They had been wrong. Richard filed the lawsuit on November 21st, 2024. Iris Mendez versus Pinnacle Financial Services Group, Inc., Diane Foster, and Karen Walsh. United States District Court, District of Arizona. Case number CV24-2847. The complaint was 32 pages long. It outlined every action, every date, every document. It included the state's determination letter as an exhibit. It included the screenshot of the access log showing Diane had never opened my evidence. It asked for damages in excess of $500,000. Pinnacle was served with the lawsuit on November 26th. They had 21 days to respond. In mid-December, their response arrived. It was a motion to dismiss. Their attorney argued that I had failed to exhaust internal remedies before filing externally. Richard called me when he received it. They're claiming you didn't give them enough time to address your internal complaint before going to the state. I filed with the state a month ago, after they closed my complaint. How is that not enough time? It is enough time. They're grasping. This motion won't succeed. What happens next? I file an opposition. The judge reviews both arguments. Then the judge decides whether to dismiss or let the case proceed. When will that happen? Probably January or February. So we wait. We wait. The holidays passed slowly. I spent Christmas alone. I spent New Year's alone. I continued applying for jobs. In mid-January, the judge issued a ruling on Pinnacle's motion to dismiss. Order denying defendant's motion to dismiss. The ruling was 12 pages long. The key section was on page 8. Plaintiff adequately alleged that she exhausted internal remedies by filing a complaint with HR and receiving a formal response. The fact that HR allegedly failed to review her submitted evidence does not negate exhaustion. Rather, it supports her claim that the internal process was pretextual. Plaintiff's subsequent filing with the state agency was timely and proper. Defendant's argument that plaintiff should have waited longer or pursued additional internal appeals is without merit. The complaint states plausible claims for retaliation and wrongful termination. The temporal proximity between plaintiff's protected activity and the adverse employment actions, combined with the alleged procedural irregularities in HR's handling of her complaint, is sufficient to survive a motion to dismiss. Motion denied. Case proceeds to discovery. I read the ruling 3 times. Then I called Richard. "We won," he said. "What does that mean?" "It means the case goes forward. We move into discovery. We can subpoena documents, we can depose witnesses. We can force Pinnacle to produce everything related to your termination. The PIP, the compliance report, all of it." When does that start? Next month. I'll send them discovery requests. They'll send us their requests. Then we start gathering evidence and taking depositions. How long does discovery take? Usually 4 to 6 months. And then? Then we either settle or go to trial. Do you think they'll settle? Richard paused. I think once they see what we have in discovery, they'll realize they can't win at trial. The access log alone is devastating. But we have to go through the process. Discovery began in February. Richard sent Pinnacle a request for documents. The request was 43 pages long. It asked for everything. All documents related to my employment. All documents related to the compliance report I filed. All documents related to the PIP. All documents related to my internal retaliation complaint. All communications between Karen, Michael, Diane, and Todd regarding me. All documents related to the decision to terminate me. All HR policies and procedures. All training materials on retaliation. Pinnacle's attorneys responded with objections. They claimed the requests were overly broad. They claimed some documents were privileged. They claimed the burden of production was unreasonable. Richard filed a motion to compel. The judge held a hearing in March. I did not attend. Richard said it wasn't necessary. The judge ruled mostly in our favor. Pinnacle was ordered to produce the requested documents within 30 days. Privileged communications between the company and their attorneys could be withheld. Everything else had to be produced. In April, the documents started arriving. They came in batches. Emails, performance reviews, PIP documents, HR policies, meeting notes. Richard reviewed everything. In early May, he called me. "I found something," he said. "What?" "An email chain between Diane and Michael, dated May 15th, 2 days before they put you on the PIP." "What does it say?" Diane asks Michael if he's concerned about potential blowback from the compliance report you filed. Michael responds that they need to document performance issues now to establish a paper trail. I was silent. That's direct evidence of retaliatory intent, Richard said. They were planning the PIP before they had any legitimate performance concerns. They were creating a pretext. Can you use that at trial? Absolutely. It's smoking gun evidence. What else did you find? Karen's meeting notes from your PIP check-ins. She wrote that you were meeting stated requirements, but that Michael wanted her to maintain pressure. So they knew I was doing what they asked. Yes, and they proceeded with termination anyway. Anything else? Diane's notes from when she closed your internal complaint. She wrote that she reviewed the complaint, but there's no mention of reviewing your evidence. And we have the access log showing she never opened the file. So she lied in her response email. Yes. What happens now? Now we schedule depositions. I want to depose Diane, Karen, Michael, and Todd. I want them on the record under oath explaining these documents. When will that happen? Probably June or July. The depositions were scheduled for late June. Diane Foster was deposed on June 23rd. I was allowed to attend. Richard said it was my right. The deposition was held in a conference room at Richard's office. Diane arrived with Pinnacle's attorney, a man named James Whitmore. A court reporter was present to record everything. Richard started with basic questions. Name, title, how long with the company, job responsibilities. Then he moved to my complaint. Ms. Foster, you received a retaliation complaint from Iris Mendez on June 18th, 2024, correct? Correct. And that complaint included 47 pages of supporting documentation, correct? I believe so, yes. Did you review that documentation? Diane hesitated. I reviewed the complaint. I asked if you reviewed the documentation, the evidence file that Ms. Mendez submitted. I reviewed all relevant materials. Richard slid a document across the table. This is an access log from your company's document management system. It shows 0 views of the evidence file Ms. Mendez submitted. How do you explain that? Diane looked at her attorney. James spoke. You can answer. I may have reviewed a printed version, Diane said. Did you? I don't specifically recall. Ms. Foster, in your email closing the complaint, you stated you had conducted a thorough review of all evidence. Were you being truthful when you wrote that? I was being truthful based on my understanding at the time. Your understanding of what? That I had reviewed the complaint appropriately. But you didn't actually review the evidence Ms. Mendez submitted, did you? I reviewed what I believed was necessary to make a determination. That's not what I asked. Did you open the evidence file that Ms. Mendez submitted electronically? I don't believe I did. So when you told Ms. Mendez you had conducted a thorough review of all evidence, that was false. James interrupted. Objection. Argumentative. Richard moved on. Ms. Foster, do you know who Todd Brennan is? Yes, he's a branch manager. Were you aware that Ms. Mendez had filed a compliance report regarding Mr. Brennan? I was generally aware, yes. Were you aware that the PIP issued to Ms. Mendez specifically asked her to improve her relationship with Mr. Brennan? I wasn't involved in drafting the PIP. But you were aware of it? Yes. Did it concern you that Ms. Mendez was being asked to improve her relationship with someone she had reported for a compliance violation? The PIP was based on performance issues. That's not what I asked. Did it concern you? I trusted that the managers involved were acting appropriately. The deposition continued for 4 hours. Richard went through every document, every email, every timeline discrepancy. Diane's answers became increasingly defensive. When it ended, Richard looked satisfied. That went well, he said after Diane left. How can you tell? She contradicted herself multiple times. She admitted she didn't review your evidence, and she had no good explanation for why the PIP asked you to improve your relationship with someone you'd reported. The other depositions followed in July. Karen was deposed on July 8th. Michael was deposed on July 15th. Todd was deposed on July 22nd. Richard took detailed notes during each one. After Todd's deposition, he called me. "We have everything we need," he said. "What does that mean?" "It means the case is ready for trial. But it also means Pinnacle knows they're going to lose." "How do you know?" "Their attorney called me yesterday. He wants to discuss settlement." My heart rate increased. "What did you say?" "I said I'd discuss it with you and get back to him." "What are they offering?" "They haven't made an offer yet. They just want to open negotiations." "What should I ask for?" Richard paused. "Here's my recommendation. Your back pay from termination until now is about $60,000. Your lost benefits add another $15,000. Front pay, what you would have earned if you'd stayed, could be another $100,000 over 2 years. Emotional distress damages, given the egregious nature of the retaliation, could be another $100,000. Then there's punitive damages. For intentional, willful conduct like this, punitive damages can be substantial." "What's substantial?" 2 to 3 times compensatory damages. So if compensatory is $275,000, punitive could be another $500,000. That's over $700,000 total. "Correct, but they'll never agree to that. We'll negotiate." "What do you think is realistic?" "I think we can get $400,000 to $500,000, maybe more if we push." "And if they don't agree?" "Then we go to trial, and we let a jury decide." "What would you recommend?" "I'd recommend we start high and see where they land. If they make a serious offer, we can evaluate it. If they lowball us, we prepare for trial." "Okay." Richard called Pinnacle's attorney the next day. The settlement negotiations began. They offered $200,000. Richard countered with $750,000. They came back with $300,000. Richard countered with $600,000. They came back with $400,000. Richard called me. "They're at $400,000. That's back pay, front pay, emotional distress, and a modest punitive component. It's a reasonable offer." "What do you think?" "I think it's fair compensation. It's not everything we asked for, but it avoids the risk and delay of trial. And it includes a confidential settlement, which means they'll never admit wrongdoing publicly." "But I'd have to sign a non-disparagement agreement." "Probably, yes." "So I couldn't talk about what they did?" "Not publicly, no." I thought about it. "What if I want to go to trial?" "Then we go to trial. We have a strong case, but trials are unpredictable. Juries can be unpredictable. There's always risk." "What would you do?" "If it were me, I'd take $400,000 and move on. But it's your decision." I thought about the past year, the termination, the job search, the unemployment, the waiting. I thought about Diane's deposition, the admission that she hadn't reviewed my evidence. I thought about the email between Diane and Michael planning the PIP before they had any legitimate concerns. The truth was documented. The state investigator had seen it. The judge had seen it. Diane, Karen, Michael, and Todd had all been deposed under oath. The truth was on the record. Whether a jury heard it in trial or whether we settled, the truth was established. "I'll take the $400,000, I said. "You're sure?" "Yes." Richard negotiated the final terms over the next 2 weeks. The settlement agreement arrived in mid-August. It was 23 pages long. Confidential Settlement Agreement. Iris Mendez versus Pinnacle Financial Services Group, Inc., et al. Case number CV24-2847. The terms were clear. Pinnacle would pay $400,000 within 30 days. The payment would be split into taxable wages and non-taxable damages as recommended by a tax specialist. Pinnacle would provide a neutral reference letter. Both parties would sign a mutual non-disparagement agreement. The settlement would remain confidential. Pinnacle would not admit liability or wrongdoing. The case would be dismissed with prejudice, meaning I could never refile. I read the agreement carefully. Then I signed it. Richard filed the settlement with the court on August 28th. The judge approved it on September 3rd. The payment arrived in my bank account on September 18th. After Richard's contingency fee and costs, I received $257,000. I stared at the number on my screen. $257,000. For reporting a compliance violation. For documenting retaliation. For refusing to accept that HR had thoroughly reviewed evidence they never opened. I thought about calling someone to celebrate, but I didn't. I simply sat at my kitchen table and felt relieved. The next week, I received 2 job offers. One was from a regional bank, compliance manager position, $65,000 per year. The other was from a credit union, senior compliance officer, $78,000 per year. I accepted the credit union position. I started on October 1st, 2025, 17 months after I reported Todd Brennan's compliance violation, 14 months after I was placed on the PIP, 13 months after I was terminated. On my first day, during new employee orientation, the HR director reviewed the company's policies. One section covered the whistleblower protection policy. If you ever witness or suspect misconduct, we want you to report it, she said. We have multiple channels for reporting, and we take retaliation very seriously. If you report in good faith, you're protected. Period. I nodded. After the orientation, I walked to my new office. I sat at my desk. I opened my laptop. I thought about Diane Foster closing my complaint without reading my evidence. I thought about the access log showing 0 views. I thought about the state investigator who actually reviewed everything. I thought about the judge who denied Pinnacle's motion to dismiss. I thought about the depositions where the truth came out under oath. The system had worked. Not because HR did its job, but because I documented everything. And because when HR failed, there were other authorities who would listen. I opened my email. I had work to do.